WFSU.
Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on our docket today is in re amendments to rule regulating the Florida Bar 5-1.1G. I'll first recognize Mayanne Downs.
Good morning. Thank you, Chief Justice, and may it please the court. My name is Mayanne Downs, and I'm the chair of the task force on IOTA Funds, which was a group put together by this court, as you very well know, in October of 2019 to examine the status quo for the use and direction and spending and distribution of IOTA monies pursuant to the IOTA program in the rule that Justice Kennedy just identified. In the charge that you gave us in the administrative order, you told us to look at the most effective way to deploy IOTA monies. And in doing that work, to consider the possibility of alternative distributions, to consider the possibility of reporting requirements, and keeping in mind that this court determined that this group should give priority consideration to the need for funding direct legal services to low-income litigants in Florida, and you directed us to report back by September 20th of 2020, September 15th, excuse me. In conducting this work, we formed a number of subcommittees. We met 12 times over 10 months. We reviewed about 5,600 pages of documents and information from the Florida Bar Foundation, the sole designated charity for IOTA monies under the existing rule. We conducted a national survey of IOTA programs, including Canada and British Columbia. And the results of that survey are attached to our report. We held 2 public hearings. We considered oral presentations and written comments from the grantees and the foundation. And we amended many of our initial proposals based on input that we got from the Florida Bar Foundation and its grantees. All meetings of the task force were public. They were all agendaed in advance, noticed in advance, and all the information we collected in the hearings we held were published for all to read and review on our website. The task force consisted of Miami Third DCA Judge Ed Scales, who has served for quite some time on the foundation board as this court's liaison and appointment. John Stewart, the then president of the Florida Bar, longtime member of the Board of Governors and longtime foundation board member. Karen Lattis, 30-year executive director of Florida's oldest and largest legal aid organization, also from Miami. Scott Thomas, the former chair of the Florida Elections Commission from Jacksonville. Tampa lawyer Hala Sandridge, then president of the Florida Bar Foundation. Naples lawyer Laird Lyle, longtime member of the foundation and Florida Board of Governors. And I was appointed as chair, former president of the Florida Bar, 2-time board member of the foundation, and president of the Orange County Legal Aid Society. Several of the task force members are fellows of the Florida Bar Foundation in recognition for a personal giving. I wanted
Ms. Downs, Ms. Downs, could I interrupt you?
Yes,
can you
please.
Hear me okay?
I can.
Okay. Your task force work on this has been incredible. I know it's taken a lot of hours and time out of your guys' schedule to do this. I just had a couple of things I was hoping you could clarify for me. Do you know, and this may not be information you have, but do you know during the past sort of pandemic crisis, has the foundation used any of its reserves to meet sort of what we would call pressing unexpected needs?
Well, two things. One is because there's no reporting requirement, none of us have very much information about specific works of the foundation. The foundation does a lot of good work, but it primarily distributes money to others. I can tell you, for example, as a result of meeting with individual legal aid organization members, that COVID has provided a challenge. As you can imagine, legal needs continue to grow, and the monies for IOTA have gone from 74 million down to, I think the projection for this coming year is 8 million. And certainly COVID enhanced the needs that Floridians had.
Right. Do you know if at any point, is there just any information about whether the foundation went into its reserves to assist with the past sort of crisis that we've had?
I don't really have any way of knowing that. Again, there are no reporting requirements in this rule, none whatsoever. So we don't know how those monies are spent. I do know that the Florida Bar Foundation has accessed reserves over the last decade while the monies have continued to reduce, but how that money is spent, because keep in mind the aegis, the umbrella that dictates how the money can be spent right now under the current status quo is improving the administration of justice. That's a hard benchmark to measure. So I don't know the answer to that, but I suspect they have accessed reserves.
And then my second question is your task force recommendation regarding the 10% overhead cost for the pro bono organizations. How is that formed? How is that particular percentage established by the task force?
We have a detailed description of that, Justice Grosshands, that you can find at Appendix F of our report in footnote 8, I believe it is. But a basic explanation of that is that the foundation testified, and in fact, many of us knew of this because of our work on the foundation board, that approximately 2.5 FTEs, 2.5 full-time employees, spent time administering and distributing IOTA. Now, the foundation testified they did other things. So in our assumption about overhead, we did two things. One is we identified specific overhead items, and they're set forth, as you know, in the proposed rule. And then secondly, we said that there is a cap of 15% of IOTA monies at the foundation level and 10%, as you identified, at the grantee level. Because the Florida Bar Foundation presently reports that they spend 11.3% of monies on overhead, we felt very safe with a 15% cap, which obviously, using the easy math of $10 million, would be $1.5 million. And keep in mind, there's no charity I know of, or I suspect any of us know of, who get their money unbidden. In other words, most charities have to spend 10 to 40 or more % of their overall expenses to get donations. And we've all been the recipients of calls and advertisements and events to solicit donations. These monies come to both the grantees you identified and also to the foundation by operation of law. So we feel very, very comfortable that 15% as a cap is more than enough to distribute these monies, and it's more than the foundation says that it spends now. And finally, keep in mind that our proposed rule specifically states that upon application to the court, there can be variance or the cap can be lifted, or specific crises, for example, like COVID or other expenditures could be approved.
Thank you.
And so back to just a couple of background points I wanted to focus on. The status quo right now is that there is no restriction of any kind at all in the rule. And in fact, there's not even a description about what the monies are to be used for. In 1981, when this court made mandatory the IOTA trust account interest program, this court said that the purpose of the IOTA program was to expand the delivery of legal services to the poor in Florida. Over time, as this court's administrative order to us identified, that grew to include the phrase improvement or improve the administration of justice. So right now, the Florida Bar Foundation is the sole designated charity for all of these monies. There is no reporting requirement. There is increasing need of Floridians who are poor and require assistance in domestic violence, housing matters, landlord-tenant, family law matters, matters involving children for guardians ad litem, etc. By the way, the original order of 1981 also stated that the foundation with these IOTA monies could not carry on any propaganda, kind of an interesting word, and could not attempt to influence the legislation. I mention that because it seemed to us in doing our work that the safest and most prudent way to spend IOTA monies is to spend them on providing lawyers who will in turn provide legal services to the poor. It is the purest, it is the simplest, it is the most objectively measurable way to spend these monies. And spending the monies in that fashion should insulate these monies from being a subject of criticism about compelled speech or compelled association or some of the jurisprudential matters we see developing in the law. Second,
Counsel, I'm sorry to interrupt you. Chief,
yes,
I know we're over the time. Do you mind if I ask a question?
please.
Chief, is it okay if I?
Oh, sure. Yeah, we'll go ahead.
So first of all, I just want to thank you and the rest of the task force. You obviously put a ton of time and thought into this, and a lot of your recommendations are really just kind of a good faith effort to kind of respond to what the court asked you guys to do. And the tone of a lot of the response to this, I mean, you would think that you guys had recommended, outlawing sunshine or, something. I mean, it's kind of, so I thought some of the responses were borderline uncivil. And since your time is short here, I just want to get your take, kind of big picture on what can you just to sort of explain, we have 7 people on this committee who are, share the same goals and have, dedicated a lot of their professional lives to the same objectives as, the commenters. And, the way the proposal has been received, I mean, you would think it was like from, we had asked a bunch of aliens or something to look at this. And I just would appreciate kind of your sort of big picture take to help us kind of understand why this debate in front of us is playing out the way it is.
Well, look, we understand for 40 years, these monies have dropped, as I said earlier, unbidden. Grantees, CEOs. We understand that this change is one that will make a big difference in their lives. And we attribute the hostility, which was substantial. In fact, at a hearing we had, a member of the foundation questioned who wrote the order, which is something I've never heard anybody comment upon or suggest. I mentioned it only.
I confess, I wrote the order with the court's input.
We said it, the court wrote the order. It said so right at the top and at the bottom. I mention that only because this is a substantial change. There's no question it is a significant restriction on what the foundation has been able to do. Under our rule, there will be reporting requirements, caps on overhead, mandatory distribution within a relatively short time period, 6 months, extensive information about objective data that can be used to measure the efficiency of this program. All of that represents a substantial change. Nobody who is going to come before us or appear before you today, Justice Muniz, has anything but the best interest of Florida's poor in their hearts. But I think that point takes us to what I'll say is my final point. I appreciate you accommodating me on time. Improvement of the administration of justice can be measured no more effectively than one can measure the sky. It is a subjective determination. If all of us took a quick coffee break, we'd be lucky if 2 of us agreed about how is the best way to improve the administration of justice. But nobody in good faith can disagree that transparent reporting requirements heighten efficiency and effectiveness, and that objective measures work best. And finally, that the closest, purest nexus to the original purpose of these funds and our profession is to provide legal services to the poor. We don't consider anything about any of those matters to be controversial. And I think at heart, nobody really thinks those goals are bad in any way. I've exceeded my time based on questions. We consider our role at the task force here.
Chief, if I could also.
Go ahead, Justice Lawson.
Okay, and I apologize. I've had some internet technical issues, and hopefully I'll be able to stay on throughout this. And I want to also thank you and the committee for your hard work and efforts on this. And I have some more technical questions. If I understand correctly, when it just hypothetically, if someone started a direct legal services organization and had 2 attorneys and support staff, and all that they did was with those attorneys provide the kind of services that we're talking about to indigent clients who cannot afford civil representation. And that was one model, and say it cost $150,000 a year and they were able to help 200 people. And then someone else has a model where they hire 2 professionals and support staff who recruit and train attorneys to provide pro bono services. And they're able to get a large number of attorneys. So say they have 50 to 100 volunteers, and as a result are able to provide services to 2,000 clients a year instead of the 200 for the same amount of money. And I read a lot of the comments as saying that the rule as envisioned and proposed would prohibit that kind of innovation in the provision of legal services. And as I read it, it would not. And I think the comments make that clear, but can you address that?
Yes, thank you, Justice Lawson. We worked hard to have the rule reflect the education that some of us obtained in studying how legal services are provided. And you set out 2 hypotheticals that kind of span the options that are available. And here in Orlando, we have mandatory pro bono for a voluntary bar association, And one of the things the Legal Aid Society here in Orlando does very well, as you very well know, is gets lots of volunteers pursuant to that mandatory pro bono requirement to extend the reach of legal services. We expressly stated in the rule that hourly services facilitated by IOTA money, not just provided, but facilitated, should be a reporting requirement and a consideration of selection of grantees. Both of those things are rejected by what the foundation calls the consensus rule, which is really just a codification of the status quo. But we use the word facilitate, I believe, 3 times in the
Well, and the word facilitate is in the definition of a qualified grantee organization. It's an organization that facilitates or directly provides.
Right. And those words were used very much to address the exact circumstance, Justice Lawson, that you identified. In other words, there are small organizations, particularly in rural areas in some cases, that need to use volunteers to extend their reach. And that's why we use that word. And we used it repeatedly, both in the description of the grantees and in the description of expenses that could properly be used under the proposed rule.
I have a follow-up to that. Our internal rules prohibit sort of us from talking to you while a case is pending. These are the kind of technical questions that therefore necessarily have to be handled in an oral argument. But I'm looking specifically at subdivision 9, which talks about the use of IOTA funds, and am wondering if it might, what you would think about this change. If it's the 10% of IOTA funds that can be used for administrative expenses. And I'm wondering in that particular section, if we should say a qualified grantee, and I'll just read it and tell you where I'm adding. A qualified grantee organization must expend at least 90% of the IOTA funds received to facilitate qualified legal service providers providing, and there I would add, or facilitating qualified legal services.
We would have no objection to that, Justice Lawson. I think that would probably put a finer point on the discussion we just had, the colloquy we just had.
And then I'm wondering, to clarify further, if reading on, a qualified grantee organization must expend no more than 10% of the IOTA funds received for general administrative expenses, not directly supporting the provision of qualified legal services, and then go on and establishing reserves. And the reason there is, I mean, the money support to facilitate, money spent to facilitate look like general administrative expenses. And so look like administrative expenses. So if we sort of separated out general administrative expenses and made clearer that that expenses that are directly supporting the provision of legal services are not general administrative expenses, then I think that might help clarify, and just wanted your reaction to that.
As I said, we spent a lot of time trying to get this right. We said in our report, we have no pride of authorship. I think anything that clarifies the overall intent of our rule, which, as you know, is to put as much money in the hands of organizations that can provide legal services, either directly or through facilitation, as you identify, is what we were trying to accomplish.
All right. Do you have something else, Justice Lawson?
Yeah, one more sort of technical, and in subsection D down there, expenses that other, this is defining what constitutes qualified legal services, limited to, and then D, expenses that otherwise directly facilitate providing legal services. If we added including training and technology necessary to the direct provision of qualified legal services, would you see any problem with that?
No, Justice, I wouldn't, particularly because you identified, and we were careful to put in direct legal services, because, as you know, very quickly you can mushroom a category of expenses if you don't have qualifying words. But I think that would work fine. I want to note, here I am making comments. I believe that everything you said would have the support of our task force. But I want to use that opportunity to remind this court that the task force unanimously approved our report, unanimously approved this proposed rule, and unanimously approved our response in these proceedings. I mention that, I think, in part to go back to Carlos Muñiz, Justice Muñiz's point, that while there has been criticism from those involved in the status quo, our group, executive director of a legal aid group, two former presidents, Florida Bar, one present president, the president of the foundation, all of us voted for what we ended up with. Justice
All right,
Lawson,
we're gonna need to move on to the other commenters now. But Ms. Downs, again, I want to thank you for your participation today and for your leadership of the task force, and we appreciate all the work of the task force.
it's been a pleasure and a privilege. Thank you all.
Mr. Hall.
Good morning. May it please the court. My name is Tom Hall and I represent the Florida Civil Legal Aid Association. If I could, Chief Justice Kennedy, just one housekeeping thing. Mr. McDonald, who is supposed to be here on behalf of the business law section, he has a health issue and is not able to attend this morning. He apologizes to the court, but if there are any questions directed to them, the remainder of us who are speaking will try to answer those questions. I think that the court summarized to some extent with some of the questions that were asked, some of the problems that we've actually had, the legal aid organizations have with this particular problem. As Ms. Downs said, these are the most significant changes made to this rule since its inception. And the legal aid organizations truly believe that it's going to be really, truly devastating to them in the way they do their business and how they are funded and their ability to provide legal services to the poor. The questions that Justice Lawson asked were some of the things that I was going to get to directly. For example, we raised this issue that the money can only go to the overhead at 10% includes technology and training. In the response back to our comments, Ms. Downs, on behalf of the task force, said,
Well, Mr. Hall, let me ask you this. You heard what Justice Lawson asked.
Yeah.
And you heard what Ms. Downs now just said. To what extent does that resolve the problems you previously identified?
I think it would go close to solving the problem that we're talking about the overhead. But we're listening
to. If you would, I think it'd be helpful if you explain how that solution would be deficient and what other problems you have that are unaddressed.
I think the problem is if you're going to define that exactly what it goes to. What I was going to say was Ms. Downs' response back said that money, the 10% limitation would not apply on training and technology if it was provided to qualified legal service providers. Under the rule, legal service providers are lawyers only. So for example, if you have let's say you have a $2 million case management system and your stats show that lawyers use that 50% of the time, then can you write off the 50% of the technology cost of the 2 million, or can you write off the whole thing because lawyers are using it? And I think the things that Justice Lawson were asked get to that problem, but not seeing them in the context and responding to them exactly right here, I'm not sure they'd 100% solve the problem. In the past, and this is traditionally true both in Florida and around the country, what the use of IOTA funds does is fund the overhead. Legal aid organizations get grants from other people. They often have a lot of strict restrictions on them. They cannot pay overhead out of those things. So the IOTA funds have really been used in the past to pay the overhead. There's been, as all part of this process, there's been no criticism of the legal aid organizations and what they are doing in this state and providing services to the poor. That's not been part of that wasn't part of the report. In fact,
Mr. Hall, but if I could, Mr. Hall, what we just clarified was that the rule is intended and could be clarified, as we just discussed, to say that the 10% that can go for general overhead does not include monies that are used to directly facilitate the provision of legal services. And I'm just not understanding why that wouldn't solve your problem.
I think it would, other than we think the 10% is a sort of very arbitrary number that they have no basis in fact for selecting. I mean, at least 3 members of the task force commented at meetings they had that they thought that that was a completely arbitrary number. And at one point, I think there's a discussion, and it's in the appendix that we submitted around 155, somewhere in there. A number of them are talking about that we need either a sunset provision or this 2-year study provision, because they specifically said, we don't know what the outcome of this is going to be. They really didn't analyze if you really impose this 10%, and even if you make the additions that you're suggesting, Justice Lawson, they don't really know how that's going to ultimately affect these legal aid organizations. And that's really the problem. We have no analysis of that. That's what the business laws section spoke to in their comments. There should have been a business analysis to how's this going to actually affect them. Is it really going to hurt their ability to provide services to the poor? Now, for example, there's a program, Justice Grosshand's Act, about use of reserve funds. And unfortunately, I don't know the answer to that, but we might be, one of us might be able to figure that answer out before we're over. But part of that, for example, there's a program called Florida Eviction Help that the legal aid organizations have, where people who are being evicted can go online. And one of the things that system does is help them provide an answer to an eviction process. And between, I think it was August of last year and February, when we filed our comment, more than 4,000 self-represented litigants had gone on that system, prepared and filed an answer to an eviction proceeding. It's not clear to us if that would be allowed or disallowed. It seems to be, to me at least, it seems to me that that would be disallowed under this system. And it's critical. And one of the problems that we're going to have with this is most of these legal aid organizations are headed by an attorney. They are required under this rule to certify that they're in compliance with the rule. And this is a bar rule that they're certifying they're in compliance with. So they're going to have to have a conservative approach to how they do this, because they're not going to understand whether they may be violating this rule. If, for example, a paralegal helps somebody fill out a legal form, can they have the administrative assistant who helps schedule attorneys or answer phones for them or do that?
Counsel, I'm sorry to interrupt you, but since there's a little time, let me just ask you. So it seems like these changes fall into 3 basic buckets. One is the kind of redefinition on the scope of what the aid can do. The other is the overhead issue, the 10% thing. And then the final thing is the reporting. So my impression is that there's consensus on both sides on the reporting thing. We understand what you're saying about the reserves issue, or the overhead part. As to the first part, assuming that the rule is clarified and the way the task force responded to make it clear that the debt repayment was okay, do your clients in particular, and I understand that the comments have all sort of, the commenters have all sort of coalesced behind this, whatever the other proposal is, but from your clients in particular, is it fair to say that it would not be adverse to your mission to limit what IOTA funds can do to providing services to people to actually, represent people who have legal problems?
As long as it's to represent them and not necessarily have an attorney representing them. Many of these legal aid organizations can be far more effective by having paralegals and others that are developing.
So this kind of macro question of whether to retain this amorphous administration of justice category, which could basically mean anything, your clients in particular don't have a dog in that fight.
I would say that's probably correct, but it depends. Sometimes
that's all I needed to know. Thanks.
Well, if I could just follow up a little bit, sometimes those administrative justice things help us overall in what we ultimately do because of what happens. And there's very little of those funds this last year that have gone to that. Only 2 people got an administrative justice grant, and that was about $500,000 out of the total amounts that were distributed this year. The other thing I did definitely—
and so you're saying from the IOTA funds in general?
This year from IOTA funds, it's my understanding there was about 500,000 out of the total distributed.
Which kind of suggests that the sky is falling type comments related to that are, maybe not that persuasive, at least for now. I understand the funding has fluctuated, but to the extent that that's presented as some huge catastrophic flaw in the task force recommendation, what you just said seems to undercut that.
Well, I think if you prohibit it entirely, I think that's the problem, because going forward, you don't know what they might need in the future. And that's the problem with it, that we see with that particular problem. I do want to touch on the other two issues that I wanted to touch on quickly. One is the reserves and the ability to, and having to send the money to people within 6 months of receiving it. We think that's one of the biggest flaws in the system. In the past, having the foundation have reserves available so that we have emergencies like hurricanes or the eviction thing, which is going to reach a head pretty soon as various states get lifted. If there are not reserves available to suddenly devote to those kinds of things, that is going to be very, very difficult. We're just simply not going to be able to cover those things.
Mr. Hall, it seems as I read the proposed rule, it simply says makes restrictions on the IOTA funds. I mean, there are a lot of generous people who donate not only time, but a lot of money to the foundation and these other providers. They can use those funds without any restriction from these rules to prepare for reserves. Can they not?
I think they can, but what they've done in the past is take those two sets of monies and invest them together, and then they were able to make a lot more money, and that's been a very successful thing. And that's really, really helped us in the past. And candidly, when the Great Recession hit, if it hadn't been for those reserves, the legal aid foundations would have been almost had to have shut down. So I just think it's really short-sighted to say you can't have reserves, you can't use the IOTA funds for reserves. Sometimes that actually, from a business judgment, is a very, very important thing to do.
Well, I don't think it's correct at all to say that they somehow prohibit these entities from having reserves. I don't see that anywhere.
Well, I think what happens is that because well, I agree with you that it doesn't prohibit it, but what it says, if you can't use the IOTA money for that, then that creates problems. And my time is almost up, but I did want to touch on the issue of the LRAP program. I think the biggest problem with that and the amendment they came back with is it says that's going to be considered money given to the grantees under the IRS code. And I know Justice Polson is an accountant, so he probably knows this a little better than I do, but it's very clear under the code, if somebody like the foundation gives this money to pay back the student loans, there is no tax consequence to the attorney who gets that money. But if the money is paid to the grantee, which is what this seems to suggest is going to happen, if it's paid to the grantee and they give them the money, they're the employer, under that circumstances, it is a taxable consequence to the person. And that just seems to me to be a waste of IOTA money to have it pay taxes when the provision right above it, one section above it says, if the foundation gives the money directly to them, they don't have to pay taxes. So we think it would be better to simply say something like, instead of what they said in response, to simply say something like.
Where are you exactly, Mr. Hall?
I'm sorry, what, Your Honor?
Can you point me to exactly the paragraph that you're discussing?
I can't point, yes, I can. Hang on one second. That is the, I've got it here. I made a note. It goes, well, I don't have the exact page. It's in their response to the comments. They have the language, and I thought I had it here. And I will definitely try to find it before we're done, and maybe I can pass that on to somebody else. But it's really clear that if it goes to the grantee and the grantee pays it to the attorney, then there's going to be a tax consequence. And we think that can just be covered by saying there's nothing in this rule that says you can't continue to LRAP programs. That simple statement would seem to us to solve it, and that is not overhead, for example. That would seem to cover it. I would urge the court to not adopt the rule, and if you're going to adopt a rule, adopt the consensus rule. Thank you.
Thank you, Mr. Hall. Mr. Gowdy.
Good morning. May it please the court. Thank you, Mr. Chief Justice. I represent 26 past presidents of the Florida Bar Foundation, and we thank the court and the task force and would agree that everybody's here in good faith and that people that love Florida can disagree about the policy and would like to keep the focus on that. I thought Justice Muniz summed up the three areas rather well for our discussion today. One is the reporting. Two is, I think, what I would call the definitional issues with respect to the legal services provided. And three, and what I want to focus on in my discussion with you, are the caps and the 6-month expenditure. And here's where, the task force has not provided any analysis or evidence for the numbers that have been selected here. As the court is aware, 49 other jurisdictions, the British Columbia, Australia, have these programs. And there's no evidence from any of these programs anywhere where these numbers were taken from. And if you go to pages 248 and 249 of the appendix that Mr. Hall's clients submitted, the FCLA, you'll see the transcript of the task force meeting of August 14th, 2020, and 3 members candidly concede these numbers were arbitrary. And so I've heard some good suggestions today from the court for perhaps reworking the definitional issue, the second category there. And I would urge the court to send this back to the task force with some direction on these issues. But the real concern among the 12 Florida-based commenters, as well as the 2 out-of-state commenters, is focused on these arbitrary caps, and the 6-month expenditure requirement. We don't know how this is going to impact. We seem to be taking on a grand experiment here without any.
Gowdy, just for the sake of argument, I'm sorry, Mr. Gowdy, just for the sake of argument, is there any cap on overhead expenditures that would be acceptable from your perspective? And if not, why not?
So I think a hard cap or number doesn't make sense. Some of the charts we showed, there can be great fluctuations with IOTA funding. It's not steady. So during the times when there's less money, it would make more sense for that number to go up, because you still have the same overhead. And the caps, by the way, they're for the foundation and the legal aid providers. And both the foundation and the legal aid providers have made it clear that these caps will be detrimental to how they do business.
I understand, but I guess what I'm trying to establish is, tell me if you disagree with this. Let's say we did what you suggested, sent this back for factual study, and the same task force group spent another year and came back to us and said, actually, it is what the data that we have now collected shows is that most legal aid societies wind up making do with 7% of their overhead, of expenditures on overhead. And therefore, we believe that the appropriate number is 8%, or 9%, or 11%, or whatever. You'd still be before us making the same argument. Am I right?
I think yes, in the sense that, Justice Coriel, what you should be trying to measure are things like you see in the strategic reset, which you can find on the foundation's website, is the impact of the dollar. I think, Justice Lawson gave an example a moment ago. We should be trying to figure out how much bang for our buck we're getting, not on the overhead. I'll just give you a simple example that many of my clients, including and myself, have had from serving on legal aid boards. At a legal aid, I would say that other than the executive director, the single most important person there is the chief financial officer. They're the ones that keep the ship running. They're sort of the executive officer of the ship. Are they providing direct legal services? No, but you need them. And this is what we've tried to stress. That IOTA has always provided the infrastructure that allows these legal aids to go and get the grants that are more restricted. And if you don't have a solid financial officer there in place, you won't be able to grow and expand that legal aid. Just like if you don't have a solid foundation for a building. those might be considered overhead, Justice Coriel, but the question ought to be is what impact are we making on low-income Floridians, not some arbitrary number on administrative overhead, where you can get into all types of lawyerly debates that we've been having here on the definitional section about what is direct legal services and not. And we gave you some examples of that. You know, the pro se appellate handbook was funded by AOJ funds in the past. Is that a direct legal service? No. Does it facilitate direct legal services? No. Is it have a great impact? Yes, it's used by many people. The bankruptcy basics that the pro bono committee talks to you about. So that ought to be the measurement, Justice Coriel, and you ought to ask the task force to come up with that. And the foundation has been doing this. They've had standards in place. You can go to their website and see the grants. And, you know, we would agree with the task force and the court that more transparency is good. And our consensus rule agrees in large part with the reporting requirements.
Mr. Gowdy, you're making a very practical argument and making it incumbent upon the workforce, it seems to me, to almost prove a negative. I mean, these are perhaps numbers that they think are reasonable. They don't seem unreasonable to me. Can you tell me one provider? Name one provider that's going to have to close their doors or be somehow seriously adversely affected with some specificity? Does anybody have any specific knowledge or studies on your own about in reaction to these proposed rules?
Well, no, I don't have that, Your Honor. But what I do have is we have 12 groups of commenters with a wealth of experience. And I guess I learned very early on in life as a young naval officer, you listen to those people with wealth of experience. And you have uniformly 28 executive directors telling you that this is going to be a problem in running their organizations. And I would agree with their comments that running a legal aid is different than running a law firm, is different than running a court. And if they're telling you that based on their wealth of experience, I think it deserves a fair amount of respect. Do I have a study? No, but neither does the task force. And there's 49 other states doing this. So we're now going to jump off in the middle of a pandemic to something new. Yes, sir.
I sort of have a unique maybe perspective. My wife is chairman of the board of a 501c3 that operates and provides free training education for women in poverty in Honduras. And if they can't provide their services, literally children can starve and die. And they don't have the benefit of a steady source of revenue that comes in to support the organization. And so during COVID, she and the other members of that board had to work very hard to actually raise the money to keep the doors open so that they could continue to provide the support that's necessary. And it seems like to me as a policy decision that you know, the way this works, if you have this steady source of revenue that our legal aid organizations are fortunate to have during the abundant times, the organization can grow and thrive and still provide the great services. In the lean times, as a policy matter, I think I want the money that is going to them to continue to go to provide legal services to the poor. And if that means that organizations that aren't willing to get out and work and raise the money to support, you know, the level of overhead that they had in the abundant times, that they go away and the money then goes to organizations that are willing to go out and work during the lean times to get their overhead, so that as much money as possible, 90% or some other reasonable percentage can, no matter whether it's lean or abundant, can go to the provision of legal services. That seems like a responsible model to me. And it seems more responsible to me than saying that, no, we'll just keep giving you the money with zero accountability so that you can, during the lean times, continue to pay all the general overhead at the expense of providing that money to to legal services. That and I'm just, I know it's a long statement, not really a question, but why is that not a good policy choice?
I don't think it's a bad policy choice, but let me try to address it as best I can. We're not asking for zero accountability. We agree there should be accountability.
If you're saying that you want zero limitation on the amount that you can spend on general overhead, so that in the lean times you can just stay afloat, supporting the organization just to exist, then that seems like zero accountability to me.
No, we want you to measure the impact on low-income Floridians. So we don't want zero accountability. What we're saying is arbitrary numbers aren't the way to measure accountability. The way to measure accountability is to see how the funds are being used to improve the lives of low-income Floridians, to use those metrics. And I guess, and I'm over my time, may I answer the question?
You can keep going. As you might have noticed, I have been rather generous with time.
Thank you, Mr. Chief Justice. Your Justice Lawson, my clients and I, we've been on legal aid boards during lean times. They started with the Great Recession. And what you saw the legal aid boards do then was get weaned off IOTA funds and do the things you just talked about, proactively go out and get other funding, whether it's from grants or fundraising. And we're not suggesting that 100% or we want this IOTA money to be used for direct legal services and to pay for lawyer salaries, pay for paralegal salaries, to pay for the technology and the self-help measures. We want them to get directly to the low-income Floridians. Our concern, though, is that we've just come up with a number that's looking at the expense side, and we're not looking at the output. I mean, if you had a business, you would be looking at the revenue and the profits. That would be the accountability to shareholders. And we need to come up with those accountability measures, Justice Lawson, not arbitrary numbers on the cost side. Because if they go to 20% or 25% or 30% overhead, but they help 500,000 low-income Floridians, that's a better result than using 10% of admin overhead and only helping a tenth of those people. So that's the accountability, the impact. And I don't know if I hope I've answered your question. We want accountability, but not, and I think the board, I'm sorry.
If the rule is structured so that money that is spent to facilitate the provision of legal services, the direct provision of legal services, is not included in general overhead, then that seems like it would take care of the problem that you're talking about.
Well, I think, again, and if you look at the foundation at their website and the things they try to measure, it goes to, again, all I can say is the output. And a business doesn't get, a CEO of a business doesn't get judged by how much overhead he has. He gets judged by how much profits. Well, in the legal aid world, profits ought to be helped to low-income persons, not these arbitrary numbers. The 6-month, we haven't even talked about it, but very much. The 6-month expenditure makes it very difficult. And if you don't want to use the sky is falling, very, very difficult on any type of planning by these organizations. And I think the court needs to, the one point I just want to make is, and if the comments came across as uncivil, then the lawyers who wrote them should take that responsibility. Please don't punish these organizations. They all want to help low-income Floridians. They're filled with good people who want to do this work, and they are very concerned. And the fact, I understand about Ms. Downs being proud that 7 task force members agreed to the rule, but we got 12 different groups to agree to our consensus rule. And I can assure the court that also took a lot of time and work because these groups all have different interests. And so I think the court needs to listen to the experience here just as you would listen to a chief petty officer or somebody who has that experience. And I hope the court will consider that. And again, we're for accountability, but accountability on how we help income Floridians, not arbitrary numbers.
All right, Mr. Gowdy, you want to sum up?
Yes, Your Honor, thank you. I just on behalf of my clients, we've worked very hard with all the different groups here before the court. Only some of them are speaking today. There is, we've spent a tremendous amount of time also, Your Honor, trying to do what the court directed in its administrative order to better ensure the most effective use of IOTA funds. We just fundamentally disagree with the task force's approach because the arbitrary numbers on expenditures and admin there's no evidence those will get the most bang for you.
Mr. Gowdy, thank you. We appreciate your comments.
Thank you, sir.
We're now going to move on to Mr. Shirker.
May it please the court, Elliot Shirker on behalf of the Innocence Project of Florida. If the court is inclined to amend the rule, the Innocence Project requests the court to adopt the commentary or something like the commentary suggested with the commenter's consensus rule to ensure that the Innocence Project funding by the foundation, which has been ongoing for some 15 years, would continue under amended rule. The task force notably does not object to the inclusion of the commentary. They tell the court on page 17 of their response to provide that, quote, providing legal services to low-income clients and post-conviction representation, including those for wrongful conviction, is eligible for IOTA funds. We set forth in our comments the Innocence Project's mission and how that mission is carried out to free wrongfully convicted, that is, innocent Florida citizens. We urge the court to ensure that the Innocence Project continue to carry out its mission. Thank you.
All right. Thank you for your admirable brevity.
Thank you.
Okay.
I'll try to emulate my colleague.
Yeah, Mr. Cantero. You got a hard act to follow, Mr. Cantero.
I do, Your Honor. Maybe I should just say you should keep in administration of justice issues and sit down. But I think I'll need to elaborate a little bit. Your Honors, since the inception of the IOTA program, the very inception, the definition of how the funds were to be used were, and I'm going to quote from the 1989 opinion of this court, which made IOTA funding mandatory, went from voluntary to mandatory in 1989, and emphasized that the funds were to be used to fund programs which are designed to improve the administration of justice or to expand the delivery of legal services to the poor. And ever since then, in all the amendments to the rules and all the opinions addressing the rules, that term, improve the administration of justice, has been in there. It's even in this court's administrative order, creating the task force and asking the task force to study the issue. And it's even in the task force's report. So that has always been in the rule.
Sorry to interrupt you. Could I ask you a question? How does the administration of justice issue relate to this strategic reset? Because when I read prong 3 of the reset and I see that the foundation wants to quote unquote serve as a catalyst for broad-based systemic change and innovative solutions to, blah, blah, blah. That to me sort of is the best reason to eliminate something as amorphous and potentially contestable as improving the administration of justice and just focus on actually, representing clients who have civil legal needs or, helping people help themselves through a do-it-yourself form or whatever. What's wrong with sort of narrowing the focus, especially given the limited resources that we have?
Your Honor, I don't think there's anything wrong with defining administration of justice. And if the court wants to send us back to work out a definition, I don't think, oral argument is the place to do it. But I don't have a theoretical opposition to defining administration of justice. But let me emphasize that the task force has not identified any wrongful use of the funds under the rubric of administration of justice. In fact, the task force subcommittee at Appendix F3 and 4 of the task force report conceded that there was no indication whatsoever that IOTA funds have been improperly used by the foundation.
But do you mind, I'm sorry, but do you mind addressing, I'm curious, I mean, what does it mean to serve as a catalyst? And I understand who you're here representing, but to me, this whole administration of justice thing kind of relates to this. I mean, if you
this is frankly the first time I hear that term.
Change. What is that?
Yeah, I'm sorry to interrupt. Frankly, this is the first time I hear that term because the language in the reset was not part of the report, not part of the responses. And so I'm not really sure, that's certainly not part of the rule right now, but what administration of justice programs have been used to do, and this responds not just to your question, but to Justice Lawson's question, it doesn't fall under facilitating legal services because what they've done with it, and we identified, and the Pro Bono Services Committee has identified several pro se programs, for example, that the administration of justice has been used for. The Pro Se Appellate Handbook, the Bankruptcy Basics, the iDignity, self-help hotlines. To use Justice Lawson's analogy, you can use money for hiring 2 attorneys to do work for the poor, or you can use the money to help 200 lawyers do pro bono work. But
but Mr. Cantero, these what you're pointing to now are things that I think, based on the way the conversation has gone today, I think you could see that we might be likely to address those concerns. But beyond that, I mean, beyond the helping facilitate people get information about pro se representation, beyond facilitating pro bono representation, those sorts of things, obviously that they have great merit. They are aimed at directly helping individuals with their immediate legal needs. But we get beyond that. That's where I think we get into questionable and potentially troublesome areas that are of concern. So address those other areas.
Yes, Your Honor. And if I may, it's hard to shoot at a target when you don't know what the target is, because the task force's report does not identify any use of funds that they would object to and say, we don't think this is appropriate, and in the future, we should not authorize that kind of appropriation.
Well, let me give you a target then. Serve as a catalyst for broad-based systemic change.
Yeah, I'm not going to defend that, Your Honor, because I don't, like you, I don't know what it means. I wasn't on the foundation, nor was I involved in the reset. But to address Chief Justice Kennedy's question, there is a concern that facilitates legal service, providing legal services does not include pro se clinics, does not include a pro se handbook, because you're not facilitating the provision of legal services.
I get that. I understand what you're saying.
So I would hope that it would include, facilitating pro se help, and also include administration of justice.
If we were going to take that approach, what other specific things should we include?
Should you include perhaps court programs that will educate, kind of the same thing, educate litigants, court programs that are maybe innovative programs, haven't been done before, that the court wants to experiment with, but there's no funds for it, and maybe you want to have a pilot program. The administration of justice funds have been used to help fund even programs of this court that have been established, commissions and things like that. So I believe that it should help those as well. So if the court wants to define administration of justice, we certainly have no problem defining it, but we do think that removing it is going to have effects in not being able to help all kinds of pro se litigants that even this court has agreed in prior opinions that no matter how much money you throw at it, no matter how many people you hire, no matter how many pro bono attorneys we have, we will not be able to represent every indigent that needs representation. And there will always be, at least for the foreseeable future, pro se litigants. And to the extent that we can educate them, it's going to help not only them, but it's going to help the court system as well. So in conclusion, I know my time is up, and like everybody else, I appreciate your indulgence. So in conclusion, I just want to say, if the court is going to adopt any rule right now, we ask that it adopt the consensus rule and then send it back to study specific issues that have been identified, specific concerns that the court may have, to then further amend the rule, but at least knowing that everybody agrees that this rule is not going to have a cataclysmic effect. Now, you may or may not disagree with the providers that say it's going to have a cataclysmic effect, but at least we can guarantee that it won't by adopting the consensus rule and remanding for further study and further discussion. I appreciate your indulgence, and I appreciate the task force work and your work on this. Thank you for your time.
All right, thank you, Mr. Cantero. Again, I want to thank all of the members of the task force, Chairman Downs for her leadership of the task force. I also want to thank all those who participated in the argument, expressing concerns about the work product of the task force, as well as the others who submitted comments. This is an important issue, and we understand people have different perspectives on it. So we certainly appreciate the engagement on this issue. The court will now stand in recess for about 10 minutes before we take up the second case on today's docket. The court will now proceed to the consideration of the second and final case on today's docket, Boston versus the state. Counsel?
Thank you, Your Honor. Good morning. May it please the court. My name is Lori Wilner. I represent Mr. Boston in this proceeding, and I would like to reserve 5 minutes for rebuttal. There's no dispute in this case that the trial court erred in placing the burden on the defense rather than on the state. This legal error cannot be found harmless under the facts of this case, because when evaluated properly, the evidence shows that Mr. Boston could have been entitled to immunity. This court in Dennis stated that an error in that type of proceeding may be harmless. And the First DCA in the First Boston ordered a new immunity hearing for Mr. Boston. And yet when the case came back from this court, the First DCA said that the verdict rendered harmless any error in the immunity hearing. But the verdict should only be the starting place of the analysis. When the burden is, should I?
Excuse me,
You have a
counsel.
question?
Wouldn't this be a better case for you if your counsel hadn't waived his right to a separate immunity hearing?
Yes, in a lot of regards it would, Your Honor. However, if the hearing had been held, say, the day before trial, if my client had testified, which he believed he had to because he had the burden, that evidence still would have been used by the state or could have been used by the state in the trial itself. So the timing of the hearing isn't the dispositive factor here.
I agree that the timing isn't dispositive, but the waiver may be. And I guess my question is, since you agree that this would be a stronger case for you if your client hadn't waived a separate hearing, tell me how the case would be better for you if he hadn't waived it.
Well, the way the case would be better would be if the trial court placed the burden on the state.
Well, no, I know, but that's not my question.
I understand, Your Honor.
What are we to make of your client's knowing and intelligent decision with counsel to waive a separate hearing? You've conceded that your argument would be stronger had he not made that waiver. My question is, how would it be stronger? Tell me what effect to give to your client's waiver.
Yes, Your Honor. Two things. One, I'm not conceding that the case would be stronger. I'm conceding that the facts would be stronger. And the reason that my client waived the hearing being held, agreed to it being held during the trial is not in the record. And in all due respect, Your Honor, those type of decisions are often made for the convenience of the trial court and for the convenience of the witnesses so that they don't have to be called back in again. I don't think there's any legal effect to my client waiving having the hearing heard during the trial, other than the fact the legislature says this should be a pretrial hearing. And I think everyone agrees that it should be.
Is that a common practice to waive this pretrial hearing and just have it heard during the trial?
Your Honor, I talked to many of the trial lawyers in my office to try and figure that out. And apparently it is because it is convenient for everyone. But in order to affect the intent of the legislature, it should be done pre-trial. But in Mr. Boston's case, the fact that it was heard during the trial is separate from the question of whether or not the error in denying the motion for dismissal was rendered harmless by the verdict. And when you look at that and the facts of this case, as this court in Dennis said we needed to, as the third DCA said in Valdez, supplemented by the state, you have to look at the facts of that case. And frankly, in Valdez, the facts of that case don't support immunity for Mr. Valdez, whereas the facts in this case, the undisputed facts, could support immunity. Now,
let me ask you. I'm just trying to struggle to understand. You acknowledge that the state has now proven beyond a reasonable doubt to the satisfaction of a correctly seated jury that your client did not act in self-defense. Is that correct?
Yes.
Okay. And the standard at the pretrial immunity hearing would be a lesser burden, the evidentiary burden, correct?
Yes.
Okay, so the first DCA concluded that because of the higher burden and your client's opportunity for a fair trial at which he could present that immunity, that defense, that completely cures any issue. And as a matter of law, it seems like it would. Your client had due process, had the opportunity to present the self-defense defense in this setting that he elected to present it in. So
Your
he
Honor,
was not deprived of any due process and had his day in court with all the rights guaranteed by the Constitution. Why isn't that a complete cure?
because, Your Honor, the right that Mr. Boston did not receive was a proper hearing. In order to go along with
procedural. He didn't receive a procedural right, but he wasn't denied due process, procedural due process. So in the absence of a constitutional violation for not having the hearing, I don't know why the trial didn't provide all constitutional rights. And he waived, as Justice Correal's questions.
Your Honor, in any type of harmless error analysis, you have to look at the individual case. There cannot be a rule of law that says a jury verdict cures all errors.
Why not?
Pardon?
All procedural errors?
Your Honor, this was more than a procedural error. Anytime the burden is placed on the wrong party, that can indeed affect much more than the procedure. In this case, the reason it's harmful is because Mr. Boston may have been entitled to immunity. Based on all of the undisputed facts of this case.
Why can't we say that we know that he wasn't entitled to immunity because he got to present everything he would have presented at the hearing that he elected not to have in front of a jury, and they found beyond a reasonable doubt that he committed the crime and did not act in self-defense. So that's where we are. Why didn't?
I'm sorry, because, Your Honor, what we need to look at is the evidence through the fact finder, which for the stand your ground hearing was the trial judge. And the perspective of the trial judge is colored by the burden and how that trial judge perceives the evidence. In this case, if the burden had been placed on the proper party, the trial judge is looking at the evidence in a totally different way. Did the state meet its burden? Now, granted, the effect of the erroneous ruling may have been Mr. Boston testified or did not testify.
So the state's burden under our current precedent would be to demonstrate that he did not act in self-defense by a lower standard than the jury found that the state met its burden, correct?
Correct. But Your Honor, I think that, I'm sorry.
Okay.
I think that conclusion ignores the reality of what happens in a situation like a motion to dismiss immunity hearing. Because if the trial court, as the finder of fact, looks at the evidence that is presented the way it's supposed to be, Mr. Boston could be entitled to immunity. And that's why it's imperative that this court gives him that new hearing.
But was there any procedural or other violation that prohibited the jury from viewing the case correctly? I mean,
yes, Your Honor, what prevented the case never should have gone to the jury if it had been done properly. This is the ultimate dispositive motion. Unlike a motion to suppress, where if evidence gets admitted erroneously and the jury convicts, the analysis does not end with the jury verdict. You look at other factors. Was there other evidence that rendered the error in admitting that evidence harmless? Did the individual confess? In this case, when you look at all of the facts, undisputed facts that Mr. Tucker picked up the level prior to the time that Mr. Boston picked up the hammer, when you look at the testimony of everyone, and indeed the presentation by the state at the trial, it is possible that under a proper hearing that Mr. Boston would have been entitled to immunity. In that
counsel,
case,
I'm sorry, counsel. Is it therefore a fair construction of your position to say that section 776.032 and Dennis stand for the proposition that an immunity hearing is unwaivable, that it must occur prior to trial, or it is fundamental error? Is that a
no,
fair
Your Honor,
summary
that's not
of
my
your
position at all.
Okay, then help me understand what your position is.
I think best practice is obviously that you have it pre-trial as dictated by the legislature. However, if a trial court in running their courtroom says it'd be best for us, I don't have time on my motion calendar, let's just hear it during trial, and it proceeds that way. Now, to go along with that best practice, if you're going to hear it like that, then do that part of the hearing outside of the jury, almost like a proffer. But my point is this: where there is an improper hearing, the appellate courts need to review that for harmless error. And the only way to review for harmless error is to look at the facts of the case. If this court were to rule that the verdict cures the error in every denial of a motion for immunity, a motion to dismiss based on immunity, then that becomes undoable. I mean,
I understand that argument, but rather than smack that particular straw man, let's deal with another holding that results in an affirmation of the conviction, which is that we find that it wasn't harmful error on these facts because of your client's waiver, which goes back to the question I asked earlier, which is, let's assume we don't go as far as the parade of horribles you're suggesting. We don't say that the jury's verdict cures every procedural harm. Fine. But what if we say that the waiver here had the effect of answering the question before us? You lose, right?
Your Honor, I don't understand why the waiver would change the analysis other than the fact that it wasn't pre-trial. I guess I'm not understanding how the waiver affects the analysis.
Our criminal law gives rights to defendants, including the right to waive certain protections that they have on the advice of counsel.
Yes.
At the beginning of our oral argument, I asked you, wouldn't this be an easier case if your client hadn't waived? And you said yes. And what I'm trying to get at is, help us understand what effect you are asking us to give to your client's waiver. If the answer is give it no effect, court, then I'm not sure there's any way for you to win today's argument. Tell me I'm wrong.
I would never do that. Your Honor, I think the only effect that we can give the waiver is the timing of the hearing. I don't understand why the analysis changed based on when the hearing is held. It was this court that said in Dennis, it may be harmless. This court dictated to the appellate courts, do a harmless error analysis. And that is what the first DCA should have done. In the first Boston, it did not. It ordered a new immunity hearing. Then in the second Boston, it said, oh, wait a minute, Mr. Boston was convicted by a jury. Well, he was always convicted by a jury. That doesn't come into the analysis here. There's longstanding law in Florida that in order to render an error harmless, there has to be an examination of the facts of the case. The facts don't change, Your Honor, based on whether the hearing is held the day before the trial or during the trial. What changes here is the fact finder's perception of the evidence through the wrong looking glass. And if the hearing, whether it was the day before or during trial, was conducted properly, Mr. Boston may have been entitled to immunity. The case never gets to the jury. He waived the right to have, the statute provides for not being arrested, not being detained, not being prosecuted. He waived all of that, Your Honor, but he didn't waive his right to be convicted when he may have been entitled to immunity. And that's exactly what all the cases say, is the whole purpose is to not allow someone to reach that point if they may be entitled to immunity. And again, in Valdez, in Little, in the other trial cases that have occurred.
I have the same argument, same question that Justice Coriel has, and that your client, by his own choice, elected to have the hearing coterminous with the trial. So that was his decision. And you seem to be saying that he couldn't waive that. And so there was harmful error because he had the hearing at the same time. Is that?
I'm sorry, Your Honor, if I'm giving that impression. That is not at all what I am arguing. I am arguing that the effect of the waiver was only to go to the timing of the hearing. My argument is that the hearing was improper, not because it was heard during the trial, because that's the way the trial judge wanted it. It was wrong because the trial judge didn't place the burden on the right party, and under the facts of this case, that error cannot be rendered harmless. I see that
the jury placed the burden on the right party, correct? You agree that the jury placed the burden on the right party?
Yes, Your Honor.
They were instructed. Okay. And
yes, Your Honor, I do agree with that. My argument is that it should never have gotten to the jury.
All right, counsel, you're in your rebuttal time now. You can keep going, but you're consuming your time.
Yes, Your Honor. I'm willing to reserve the rest of my time unless Justice Lawson would like me to continue. Thank you.
Counsel.
Thank you, Mr. Chief Justice, and may it please the court. Christopher Baum for the state. Dennis versus State makes clear that this is a simple case. There, the court held that section 776.032 granted defendants a right to avoid being subjected to trial. Now here, petitioner waived that right even after he had heard before the jury was sworn that the court chose the incorrect standard. Now, to the extent that petitioner now argues that he didn't waive the right to a proper hearing, Dennis also makes clear that that was harmless error. In Dennis, for example, the trial court did not hold any pretrial evidentiary hearing. Now, as in Dennis, the jury rejected petitioner's claim of self-defense beyond a reasonable doubt. As in Dennis, the petitioner does not contend that his trial was unfair in any way. He does not contend that his ability to present evidence on his self-defense claim was limited in any way. And he does not contend that he would present any different evidence at a new pretrial immunity hearing. Therefore, Dennis controls. And
counsel, I'm sorry to interrupt you. So if we take the guilty plea and reservation scenario out, is the practical effect of what your position, and if we were to decide this case the way you're asking us to, that basically the only way to address an error in the stand your ground hearing is through a writ of prohibition, that if that avenue doesn't happen, then essentially if the person might be acquitted or if they're found guilty, and there may be a problem that the self-defense instruction was wrong or whatever, but basically as it relates to the stand your ground issue, does that basically go away if the writ of prohibition route isn't taken?
I think that's right, Your Honor, because as in Dennis, I mean, the court said in Dennis that the right that the legislature created was to avoid going to trial. And if the defendant wants to avail himself of that right, he should seek a writ of prohibition. Or in this case, he could have moved to separate the trial from the immunity hearing or sought a writ of prohibition after the trial court chose the incorrect standard. And I think that the remedy that petitioner requests at page 22 of his initial brief belies the notion that there was any harmful error in his trial, because petitioner requested that he receive a new immunity hearing. And if he was not entitled to immunity after that hearing, he asked that his conviction be reinstated. So I don't understand the argument that the error of choosing the incorrect standard somehow was harmful error as to the conviction itself. Petitioner's other arguments are effectively irrelevant because any purported error relating to petitioner's trial strategy resulted from the invited error of holding his hearing and the trial at the same time. So for all these reasons, we think that Dennis controls and that this is a relatively simple case. Unless the court has any further questions, the state respectfully submits that the decision below should be approved and that the court should hold that as a general matter, when a jury is properly instructed as to the self-defense claim, and where the defendant does not contend that his trial was unfair in any way, that his ability to present self-defense evidence was limited in any way, or that he would present different evidence at a new immunity hearing, that the jury's rejection of his self-defense claim beyond a reasonable doubt cures any error in applying the incorrect standard to the stand your ground motion.
All right, thank you, counsel. Rebuttal.
Thank you, Your Honor. I question when Mr. Boston was supposed to contend those factors from Dennis. Is the trial lawyer supposed to stand up when the motion to dismiss is denied and say, Your Honor, I would have done the case totally different if you had put the burden on the right party? Or is Mr. Boston to say, as he did in his initial brief, I would have done this differently. I might not have testified. I would have presented different evidence. And I do agree that Dennis controls. But Your Honors, let's think about what the remedy would have been if this court had ordered that Mr. Dennis was entitled to a new immunity hearing. He would have had the exact same burden. It was 2010. It would have been exactly the same as the trial. That is not the case here. The legislature has said we want to have a determination of immunity prior to trial, or in this case, prior to conviction. And the argument that Mr. Boston was to contend all of those factors, well, I don't deny that the trial was fair. What I deny is it shouldn't have gotten to the jury. The error was in the hearing itself. And this court says, and frankly, Valdez does an excellent job, the case from the Third DCA, and going through and stating how Dennis applies. And it went through and said the verdict was only the starting point, and it looked at the analysis of the Dennis factors and said, under the facts of that case, just as this court said in Dennis, under the facts of that case, and frankly, in little, those facts support no immunity, but in Mr. Boston's case, the facts could support immunity. This is not a JOA or sufficiency of the evidence argument. Mr. Boston is not asking this court to find him immune. Mr. Boston is asking that this court remand the case back to the trial court for a proper determination with the proper burden of the evidence.
What do you make of the state's suggestion that this is a case of invited error?
Well, I think Mr. Boston agreeing to hear the case during trial for convenience and not to waiver. I think what the state is referring to is by hearing it during the hearing and feeling like he had to testify, the jury was able to hear of his prior convictions. To that extent, he maybe shouldn't have waived, and that's what I was trying to get to at the beginning. But as far as any testimony that Mr. Boston gave at the hearing, that would have been admissible anyway. So I think that's the only invited error, because the error wasn't in having the case heard during the trial. The error was because of under the facts of this case and the incorrect burden, it could not be found to be a harmless error. Mr. Boston requests that this court reverse and uphold this court's law and the longstanding rule of law from Dennis. If this court were to say that a jury verdict cures all errors in immunity hearings, it would totally negate the purpose and intent of the legislature in enacting subsection 4 to the amendment. Thank you.
All right, we thank you both for your arguments in this case today. That's the last case on today's docket. So the court will now be adjourned.